The day my son handed me a pen and said, "Just sign here, Dad," I noticed he wouldn't look me in the eye. That should have been enough. 41 years of reading people, contracts, depositions, the faces of men who thought they were smarter than everyone else in the room. And I almost missed it. Almost. But I'm getting ahead of myself. That's always been my problem. I see the end before I've told you the beginning. My name is Franklin Doyle. I'm 67 years old. I spent the better part of 4 decades as a forensic accountant for a federal oversight firm in Columbus, Ohio. That's a fancy way of saying I found money that people tried very hard to hide. Pension fraud, insurance schemes, shell companies nested inside other shell companies like Russian dolls built by liars. I was good at it. Some of the attorneys I worked with called me the surgeon, not because I was precise, though I was, but because by the time I was done with a financial record, there was nothing left that could be called intact. I retired 5 years ago, when my wife Patricia got her diagnosis. Stage 3 ovarian cancer. The kind of news that reorganizes your entire understanding of what time is worth. I didn't think twice. I handed my caseload to the younger partners, cleaned out my desk, and drove home to be with her. We had 38 years together, Patricia and I. She was a high school English teacher, patient and sharp in equal measure, the kind of woman who remembered the names of every student she ever taught. When I told her I was done working, she cried. Not because she was relieved. Because she knew what it cost me, and she didn't want that. "You'll go crazy without the numbers," she said. "I'll find new numbers," I told her. We had 2 good years before she passed. Not easy years, but good ones. The kind you hold on to. Our son Bradley flew in for the funeral. He lives in Phoenix with his wife Tammy. They have a boy, my grandson Cooper, who was 4 years old at the time and didn't fully understand what was happening except that Grandma was gone and the house smelled like flowers. Bradley stood at the graveside with his arm around Tammy, and I remember thinking he looked genuinely sad. I believed that. I don't know exactly when things changed. Grief does something to perception. It puts a soft filter over everything, makes you generous in ways you wouldn't ordinarily be. In the months after Patricia died, I was grateful Bradley called as often as he did. I told myself that was the relationship healing, the distance closing. I didn't stop to ask what he was calling about, not really. He was asking questions. About the house. About my savings. About the annuity Patricia had left. Small questions. Slipped into normal conversation like splinters. "Dad, have you thought about what happens to the Columbus house if something happens to you?" "Dad, wouldn't it make more sense to put some of that into a joint account, just so there's no hassle later?" "Dad, Tammy knows a financial advisor out here who helped her parents with exactly this kind of thing. You should talk to him." I answered politely. I said I'd think about it. I didn't think about it. Then, about 14 months after Patricia passed, Bradley called with a different kind of question. "Dad, how would you feel about moving to Phoenix?" I told him I liked Columbus. I liked my neighborhood, my grocery store, my Tuesday morning coffee group at the diner on Broad Street. He said he understood. He called again 2 weeks later with the same question dressed differently. Then Tammy started calling too, warmer, softer, talking about Cooper growing up and wanting to know his grandfather. That one almost worked. I drove to Phoenix in March, stayed for 2 weeks. The house was beautiful, I'll give them that. A 4-bedroom in a quiet subdivision with a pool and a guest room that Tammy had clearly decorated with me in mind. Cooper climbed all over me from the moment I arrived. He was 5 by then, all noise and energy. And he made me laugh for the first time in months. On the second Wednesday after dinner, Bradley spread some papers on the kitchen table. "I've been talking to a lawyer," he said. "Just to get ahead of things, Dad. Estate planning. Nothing dramatic." The papers were a property transfer agreement, my Columbus house, into a family trust that Bradley and Tammy controlled. There was also a document granting Bradley financial power of attorney, and a third form I recognized immediately, a health directive that, if signed in the configuration in front of me, would give my son the authority to make medical decisions on my behalf if I was deemed unable to respond effectively. I looked at the papers for a long moment. Then I looked at Bradley. He was watching his hands. Tammy was in the kitchen pretending to clean something. "Where'd you say this lawyer is based?" I asked. "He's local, out here. He specializes in elder law." Elder law. I was 65 at the time and had jogged 3 miles that morning. I told Bradley I needed to read everything carefully before signing anything. He said, "Of course, absolutely, no rush." His voice had the particular smoothness of someone who has rehearsed patience. I folded the documents, put them in the inside pocket of my jacket, and went to bed. That night, I lay in the guest room. Patricia would have loved and thought about the shape of what I'd just seen. The lawyer wasn't in Columbus, which meant those documents were drafted in Arizona, under Arizona law, for the benefit of Arizona residents. The trust structure was set up in a way that gave me no voting interest once the property was transferred, and the power of attorney language. I'd seen that specific phrasing before, in cases involving elderly clients who were systematically stripped of assets by family members who told themselves they were doing it for the right reasons. I thought about Patricia. I thought about what she would have said. Then I picked up my phone and called an old friend. Lewis Pratt was my counterpart for 20 years at a different federal firm, a tax attorney who had forgotten more about financial fraud than most people ever learned. We'd worked opposite sides of 3 separate cases over the decades, and had a mutual respect built entirely on the fact that neither of us had ever been able to outmaneuver the other completely. "Franklin," he said, "it's midnight." "I know. I need to ask you something." I read him the key provisions of the documents. He was quiet for a moment. "Who prepared these?" "Someone in Phoenix. My son says elder law." Another pause. The POA language is aggressive. The trust structure gives the grantor, that's you, no path to revocation once the real property transfers. Who owns the other assets right now? "I do. Outright." "Then don't sign anything," he said. "Not one page. And don't tell your son I said that." I flew home to Columbus 4 days early. I told Bradley I had a doctor's appointment I'd forgotten about. He seemed annoyed in the way people get annoyed when a plan doesn't move at the expected pace. Back in Columbus, I did what I had done for 41 years. I worked the numbers. I hired a private research firm, the same one I'd used on contract work before retirement, and I asked them to pull everything they could find on Bradley and Tammy's financial situation. Within 3 weeks, I had a picture that explained quite a lot. Bradley's architecture firm had been losing clients steadily for 2 years. He had a second mortgage on the Phoenix house. Tammy's personal credit was substantially overextended. The financial advisor he'd mentioned, the one who had supposedly helped Tammy's parents, was a man named Preston Cole, who had 2 civil judgments against him in Maricopa County for mismanagement of client funds. There was more. A conversation between Bradley and Preston Cole, obtained legally through a contact I won't name here, made reference to the Columbus property and the annuity value in terms that suggested they had been discussing my assets for at least 18 months, beginning, I calculated, approximately 6 weeks after Patricia's funeral. 6 weeks. I sat with that information for a long time. I'm not going to tell you it didn't hurt. It hurt in a way I hadn't expected. A particular kind of cold that settles behind the sternum and doesn't move. This was my son. The boy I coached in Little League. The one I drove to the emergency room at 2 in the morning when he was 17 and had decided a broken wrist wasn't worth waking me for. And I'd woken anyway because Patricia heard him on the stairs. But I also knew what the documents meant. And I knew that the longer I waited, the more my silence would be mistaken for compliance. I called Lewis again and told him what I'd found. He referred me to a colleague of his in Columbus, an attorney named Dale Whitfield, who handled exactly this type of situation. Dale had a quiet manner and a reputation I trusted. We met 3 times before I told Bradley anything at all. In November, Bradley called to ask if I'd had a chance to review the documents. I told him I had some questions and I'd like to meet in person to discuss. He flew in the following weekend without Tammy this time, which told me he'd anticipated a more complicated conversation. We sat at the kitchen table, the same table Patricia and I had eaten every dinner at for 30 years. Bradley had brought his copy of the documents, all neatly organized. He laid them out between us and began explaining, in a tone he clearly thought was gentle, why it was in my best interest to move forward. I let him finish. Then I laid out my own folder. Inside was a summary memo, 3 pages, prepared by Dale's office. It documented the Arizona trust structure, The POA language, the financial condition of Bradley and Tammy's household, the civil record on Preston Cole, and the timeline of Bradley's inquiries about my assets beginning 6 weeks after his mother's funeral. Bradley's face changed in a way I'm not able to fully describe. It was like watching a wall come down that you didn't know was holding everything up. "Where did you get this?" he said. It wasn't really a question. "You know what I did for 40 years, I said. He was quiet for a long time. Then he said I was being paranoid, that he was trying to protect me, that I was misinterpreting things. I told him I had spent 4 decades in rooms where everyone had a better story for what the numbers said, and the numbers had always been right. He left without the documents. 2 months later, I received a legal notice. Bradley, represented by a Phoenix-based law firm, was petitioning the Franklin County Probate Court for guardianship of my person and estate on the grounds that I was, in the language of the filing, demonstrating impaired judgment and an inability to manage complex financial affairs consistent with his prior competency. I read it standing at the kitchen counter on a Tuesday morning, still in my robe, coffee in my hand. I called Doyle. "Well," Doyle said, "now we have something to work with." The hearing was scheduled for a Thursday in February, in the Franklin County Courthouse on South High Street, a building I had walked through more times than I could count over the course of my career, usually on my way to give testimony. I had testified as an expert witness in that building 17 times. Several of the sitting judges had sat across tables from me in conference rooms and deposition settings. I didn't advertise this. I didn't mention it to Bradley's attorney when they sent preliminary paperwork. I simply let the process move forward. Doyle prepared our response thoroughly. We filed a counter-petition, submitted documented evidence of Bradley's financial condition and his relationship with Preston Cole, and attached certified copies of my recent financial statements, tax returns, and a letter from my physician confirming that my cognitive function was, in her professional assessment, entirely normal. On the morning of the hearing, I dressed the way I always dressed for federal testimony. Dark suit, pressed white shirt, no tie, because a tie always made jurors feel like you were trying too hard. I drove myself to the courthouse, parked in the structure on 3rd, walked in through the main entrance with my briefcase. The courtroom was smaller than the federal rooms I was used to. Bradley and Tammy were already seated at the petitioner's table when I came in. Bradley was in a new suit that didn't quite fit him. Tammy had her arms folded. When I walked through the doors, Bradley looked up, and for a moment he almost smiled, the reflexive confidence of someone who believes the outcome is already determined. Then the judge walked in. The Honorable Robert Vance, 58 years old, appointed to Franklin County Probate Court 11 years ago, previously a civil litigator for 14 years. I had known Robert Vance for 22 years. We had worked together indirectly on 2 federal fraud cases in the mid-2000s. He'd called me personally when I retired to say I would be missed. He took the bench. He reviewed the docket. And then he looked up and across the courtroom and stopped. I watched the recognition move across his face. He didn't say anything immediately. He looked at me for a moment the way you look at something you're not certain is real. Then he looked at the petitioner's table. Then back at me. "Mr. Doyle," he said carefully, "are you the respondent in this matter?" "I am, Your Honor." There was a pause in the courtroom that had a particular quality to it. Bradley's attorney shuffled papers. Tammy leaned over and said something to Bradley in a low voice. Bradley had stopped looking confident. Judge Vance cleared his throat. "For the record, I should note that I have a prior professional acquaintance with the respondent. Counsel for both parties, please approach." What followed was a 15-minute recess. I sat at the respondent's table and looked at my hands. Doyle sat beside me and said nothing because he knew I didn't need anything said. When the proceedings resumed, Bradley's attorney moved for a continuance, citing the need to evaluate the disclosure. Judge Vance denied it. He noted that the professional acquaintance was historical and non-substantive, that he had no financial or personal stake in the outcome, and that both parties had been given the opportunity to object. Bradley's attorney objected. It was noted for the record. The hearing continued. It took 4 hours. Doyle presented the financial documentation cleanly and without drama. The timeline of Bradley's inquiries. the condition of his finances, the Preston Cole connection, my own records, which showed 41 years of careful, independent management, my physician's letter, a character statement from Lewis Pratt, who had known me professionally for 2 decades. Bradley's attorney argued that my decision to conduct a private investigation of my own son was itself evidence of paranoia. Doyle asked, calmly, whether it was paranoid to review documents before signing them. Bradley's attorney argued that I had become isolated and stubborn since my wife's death. Doyle submitted my social calendar, which included the Tuesday coffee group, a monthly dinner with 3 former colleagues, 2 volunteer days a month at a financial literacy program through my church, and regular visits with Cooper that I had arranged independently, without Bradley's involvement. Bradley testified. He said he was worried about me. He said he loved me. I believe some portion of that was true. I also believe that by that point, with Preston Cole in the picture and 2 mortgages underwater, the line between worry and opportunism had become invisible to him. I testified last. I spoke for approximately 40 minutes. I was not angry. Anger is a tool with a limited range, and I had put it aside months earlier, when I decided that what I wanted was not revenge, but clarity. I laid out, in the methodical way I had laid out financial evidence hundreds of times before, exactly what I knew, how I knew it, and what it meant. I spoke about Patricia. I spoke about what she had built with me over 38 years and what I owed it to her memory to protect. I spoke about Cooper and what I hoped his understanding of the situation would be when he was old enough to have one. When I finished, the courtroom was quiet in the way that courtrooms only get quiet when something real has just been said. Judge Vance took approximately 20 minutes to deliberate. He denied the guardianship petition in full. He found no credible evidence of cognitive impairment or financial mismanagement. He noted, in language I will not soon forget, that the petitioner's own financial records raise questions more relevant to incompetency proceedings than the respondents did. He also referred the matter of Preston Cole's involvement to the Ohio Attorney General's office, since Cole had been operating in an advisory capacity across state lines in a manner that warranted review. Bradley didn't look at me when the ruling was read. Tammy was crying. Not the way people cry when they're sad, but the way people cry when they realize the story they were telling themselves has just been taken away. I stood up, buttoned my jacket, and picked up my briefcase. In the hallway outside, I sat on a bench for a few minutes, not because I was tired, just because I wanted a moment before the rest of it. Doyle found me there. He sat down beside me and didn't say anything for a while. "You knew Vance was on that docket," he finally said. It wasn't quite a question. "I saw the assignment 3 weeks ago," I said. "I didn't ask for it. I didn't mention it." "But you knew." "I knew." He was quiet again. Then Patricia would have thought that was funny. "She would have thought that was exactly right," I said. "Bradley called me that evening. I let it go to voicemail. He called again the next morning, and I let that go too. On the 3rd day I answered. He didn't apologize. Not fully. Not in the way that might have meant something. He talked around it, the way people do when they're sorry they got caught more than sorry for what they did. I listened. I didn't fill the silences for him. What I told him finally was this. I was his father, and I would continue to be his father, because that was not something that could be undone by documents or courtrooms or a man named Preston Cole. But I would no longer pretend that what he tried to do hadn't happened. That chapter existed. It was written, and we would both have to carry it. He was quiet for a long time. "Okay," he said. "I still see Cooper. We have an arrangement that I made directly, through a family mediator, that does not depend on Bradley's cooperation to function. Cooper is 6 now. Last month he asked me what I used to do for work. I told him I found things that were hidden. He thought about that for a moment, the way 6-year-olds think, completely, with their whole face. "Like treasure?" he said. "Sometimes," I said. "Sometimes more like the truth." He seemed satisfied with that. We went back to building the Lego set he'd brought over, the one with the lighthouse, and I let him decide where everything went, and the afternoon light came through the kitchen window, the way it always did in that house, falling across the table where Patricia and I had eaten 30 years of dinners, and I thought, this is still mine, all of it, still mine. I keep thinking about the Lego lighthouse. Cooper wanted to put the light at the bottom and the door at the top. And when I told him lighthouses don't work that way, he looked at me very seriously and said, "This one does." So we built it his way. And sitting there at that kitchen table, watching a 6-year-old rearrange the rules of the world with complete confidence, I thought, that's actually how most of the damage in my life got done. Someone decided the rules didn't apply to them, and nobody pushed back soon enough. Bradley didn't wake up one morning and decide to become the kind of man who files legal papers against his father. That's not how it works. It happened in increments, the way most things do. Small rationalizations, small silences, a gradual arrangement of facts into a story that made what he wanted feel like what he deserved. Preston Cole didn't create that in him. He just recognized it and walked through the door it opened. What I've come to understand, after 41 years of following money through the places people tried to hide it, is that character operates the same way a balance sheet does. Every choice is an entry. You don't get to skip the accounting. You might defer it. You might dress it up in language about protection and love and what's best for everyone. But the ledger closes eventually, and when it does, it reflects exactly what you put into it, not what you intended, not what you told yourself, but what you actually did. Bradley had real intelligence. I don't doubt that, but intelligence without integrity is just a better tool for building the wrong thing. I watched him use his mind to construct a very careful, very plausible case for why taking what belonged to me was reasonable. He was sharp enough to find the right lawyer, the right documents, the right language. What he wasn't was honest, not with me, and I don't think by the end with himself. And that gap between how smart a person is and how straight they're willing to be is where everything eventually falls apart. What carried me through wasn't anger. I want to be clear about that. Anger would have made me move too fast, show my hand, give Bradley something to work with. What carried me was patience, the willingness to sit with what I knew and let the truth finish assembling itself before I said a word. That kind of patience isn't passive. It takes more out of you than most people realize. Every week I didn't call and confront him. Every time I answered his questions about the Columbus property without letting on what I already understood, that was work. Quiet work, but real. Patricia used to say that the most underrated thing a person can do is simply refuse to pretend. Don't pretend you don't see what you see. Don't pretend a thing is fine when it isn't. Don't pretend you're weaker than you are just because someone needs you to be. She lived that. 38 years I watched her live exactly that. I think that's what Cooper is going to remember eventually, when he's old enough to understand the full shape of what happened. Not the courtroom, not the legal filings. He's going to remember that his grandfather didn't fold, didn't disappear, didn't let grief turn into surrender. He's going to remember that we built the lighthouse with the door on top because he wanted it that way, and his grandfather stayed. That's the thing worth leaving behind, not the verdict, the fact that I was still there,